Hi, everyone. A very good evening to all of you. Welcome to the AIAC, to those of you who are new, and welcome back to those of you who have been here. This is our next edition of our evening talk series titled Strategic Considerations and Technological Innovations in International Construction Arbitrations in Southeast Asia. We are pleased to have all of you here alongside our distinguished speakers and moderator, Mr. Vinayak Sriram, who I'll give a brief introduction on. Mr. Vinayak is a partner at Rosely Dahlan Saravana Partnership. He read law at the University of Durham and was admitted to the English bar in 2004. He was called to the Malaysian bar in 2007 and also holds an LLM from University College London. Drawing from his experience both as a counsel in Malaysia and a foreign lawyer in Singapore, he specializes in dispute resolution and arbitration, including multi-jurisdictional commercial disputes, aviation, banking and financial services, civil fraud, construction, corporate and shareholder disputes, energy, insolvency, professional negligence, public law, and telecommunications. I will now pass the floor to Mr. Vinayak, and I'll invite all the speakers and the moderator to the front of the stage. Thank you.
Yeah, good evening, everyone. Thanks a lot for joining us here this evening. Perfectly serviceable evening. But I believe almost every construction contract that requires arbitration. Now with cross-border projects or other, there are a number of important strategic that this goes up. And that's the first general topic. We'll also cover another very timely topic, the use of technology in preparation of contracts in general, and the preparation for and conduct of project proceedings, with an emphasis on how it works in construction. So it's very important to be very clear. Those in the discussion, the technology, finance. Sunny Koza is a distinguished practitioner from Singapore. He has an enviable commercial I would wager just about every possible factual pattern.
Mr. Vinayak, sorry to interrupt you. I think you better use the mics because we need it for the recordings. Yeah, it is. You just have to.
Thanks. I'm not going to start again. As I was saying, I wager that Pradeep has seen just about every fact pattern and legal problem that has arisen, certainly in construction and in general commercial litigation as well. Adeline is a sort of tech innovator in Malaysia. She's led the charge for the expansion of the use of technology in dispute resolution in Malaysia. Lawyers in general and in Malaysia in particular are like oil tankers. We change directions very slowly. And Adeline has been at the forefront of the push to drive dispute resolution in Malaysia, and in particular the AIAC, forward to take account of technological innovation. I'll just broadly outline how I see this discussion going. We're going to cover three general topics. The first is the preparation of dispute resolution and arbitration agreements and what to look out for and the kind of maybe technology that can be used to prepare contracts in general. We're then going to move into talking about what new technology might be available and what existing technology there is for the preparation of disputes in construction arbitrations and in the conduct of disputes. And then finally, we'll have a discussion about the sorts of protocols and agreements between parties that can be reached at an early stage in the arbitration process to avoid disputes arising during arbitration hearings as to the use of technology. So my first question is going to be for Pradeep. What maybe you could start with is identifying some strategic considerations in the drafting and casting of disputes resolution provisions, particularly from your experience in Singapore and your regional experience. What sorts of practical and strategic considerations should people like contracts managers, those drafting dispute resolution provisions take into account when they're preparing them?
Good evening, everyone. First of all, I would like to very much thank the hosts, the organizers, the AIAC for the invitation. I followed their evening talk series for some time. I'm just flattered and very honored to have the opportunity to be part of this presentation, this talk. Second thing is, I think I did in fact want Vinayak to start again because I've never, I think in a long time, heard someone say so many nice things about me. Whether they're factual or not, I think we can leave that for another day. But coming back to, I think, the topic that Vinayak identified, the sort of considerations you would want to keep in mind when it comes to putting together a dispute resolution provision. Three come to mind. The law that governs your arbitration agreement, your choice of the seat of the arbitration, as well as the institution that is going to be tasked with administering the arbitration. I'll start with the third one because I am a guest of the AIAC and I feel almost duty bound to say something favorable about the AIAC, not that it's needed, but the choice of the arbitral institution is important because they are tasked with the running, the day-to-day movement, the appointment of the arbitrators, and their rules provide the procedural timetable that's going to regulate, in many instances, the conduct of the arbitration. And you would want to look for arbitral institutions that have a reputation, a know-how for administering arbitrations, doing so quickly, and increasingly, because it's such a competitive market, being able to do so at good value. I mean, for a long time, the most popular arbitral institutions have been the ICC, the LCIA, and more recently, perhaps the SIAC. And they all are fantastic in their own right. But institutions like the AIAC, their rules in many instances mirror and overlap with the rules of the leading arbitral institutions. But one key advantage the AIAC has over the rest is, I think, the ability to administer the arbitration at a cost that's going to be a lot less than the other leading ones that I've just mentioned. So that's one thing to look out for. The second thing is, I think it's important to pay close attention to the law that governs the arbitration agreement. The law that governs the arbitration agreement, it determines in the first instance the validity of the arbitration agreement. Then it is also determinative of the question of the scope and the meaning and the effect of the arbitration agreement. Thus, the dispute in question fall within the scope of the arbitration agreement. And the third is, even if the dispute in question falls within the scope of the arbitration agreement, is the dispute in question one that's arbitrable? The issue of arbitrability. And in many instances, and most of you would be familiar, the arbitration agreement, it's the foundation of the arbitration. And in many instances, it's contained in a clause within the wider commercial or construction contract. You would have a provision towards the end of the agreement that says that the law that governs this agreement is X. And then you have provisions that go on to spell out the modes by which your disputes are to be resolved. And it's not uncommon, especially in construction arbitration or in construction contracts, to have various tiers culminating in arbitration. But what's, I think, interesting, if not troubling, is that there is no specific identification in many of these clauses about the law that governs the arbitration agreement itself. The clause that says that this agreement is to be governed by a particular law is a choice of law for the wider commercial construction contract. The arbitration agreement is in law regarded as being separate and distinct from that, which means it has its own governing law. But it is not uncommon, in fact, it's quite rare, I would say, to find contracts where the law that governs the arbitration agreement is specifically and expressly identified. And that, unfortunately, tends to, much further down the line, create issues and what I would describe as satellite litigation for parties. Just to give you an example, recently there was in the courts a dispute that was referred to arbitration arising out of a shareholders' agreement between two parties, the subject matter of which was the management of the affairs of a company incorporated in India. And a dispute arose and the claimant commenced an arbitration to refer the dispute between them relating to the affairs of that company to arbitration. The respondent then sought to challenge the commencement of that arbitration in the courts, arguing that the law that governed the arbitration agreement was Indian law, and under Indian law, disputes relating to the affairs of a corporation, complaints about oppression, complaints about corporate mismanagement are simply not arbitrable. And ultimately, on the facts, the courts found that that argument was flawed. The law that governed the arbitration agreement was the law of Singapore, under which there is no such carve-out, there's no such public policy against the resolution of disputes of that nature by way of arbitration. But I thought the takeaway for us practitioners in this space were at least twofold. The first is, if you do not specify in your dispute resolution provisions what is the specific law that governs the arbitration agreement, you then take the risk that when you commence an arbitration, a clever, crafty, well-advised respondent is going to be able to say that the dispute you're seeking to go to arbitration is not even capable of being arbitrated. In that case, ultimately, the court rejected it, but had they specified that law to begin with, it's a good chance that that satellite litigation wouldn't even have come to pass. The second, I think, takeaway from that case, and which is important for us, is it's not just important to identify a law that governs the arbitration agreement. I think we need to think about what is that law. And that, especially in the context of construction contracts, can again have serious practical implications. Like Vinayak said at the outset, the usual format in construction contracts is that you have multiple tiers. Multiple tiers providing for different modes of trying to resolve the dispute, ultimately culminating in arbitration. These are multi-tier dispute resolution provisions. Now, it's not uncommon to find a claimant having commenced an arbitration, thinking it has complied, or thinking that for various reasons it does not need to or is incapable of complying with those provisions. And so you commence an arbitration only to then find yourself on the receiving end of a challenge on the basis that you have not complied with those various tiers, those conditions to arbitration. And the outcome of that challenge, again, is going to turn on the law that is determined to apply to your arbitration agreement. Correct me if I'm wrong, but under Malaysian law, I think preconditions to arbitration the failure to comply with them, I think, is an issue that is characterized as going to the jurisdiction of the tribunal.
Yeah, that's correct.
Okay, but the position elsewhere, in, for example, England, and more recently, I think the trend in Singapore is that the failure to comply with these preconditions to arbitration is not an issue that goes to jurisdiction, but rather it's an issue that goes to the admissibility of the claim. And so again, depending on the law that is found to govern your arbitration agreement, the consequences and the outcome of that challenge would differ. If it is found to be Malaysian law, a challenge along those lines would mean that the tribunal would be confronted with a challenge to its jurisdiction. And if the tribunal finds that it has no jurisdiction, that's the end of the matter. It cannot go on to deal with the merits. And if it goes on to deal with the merits, then that award is exposed to a challenge on the ground that it was made in excess of jurisdiction. The lack of jurisdiction is a recognized challenge to set aside or to resist the enforcement of arbitral awards. But on the other hand, if it turns out that the law that governs the arbitration agreement is, say, English law, Singapore law, that challenge is then properly characterized as being to the admissibility of the claim. And the legal treatment and the outcome of that is different. So take, for example, a recent case in Hong Kong where there was a challenge along those lines to an award handed down by an arbitral tribunal. And the respondent argued that it was made in excess of jurisdiction because the preconditions to arbitration hadn't been complied with. It was crafted as being a challenge based on a lack of jurisdiction because that's the recognized ground. But the highest court in Hong Kong saw through it and said, this is an issue that turns on the law that governs the arbitration agreement. Under the law that was found to govern the arbitration agreement, it's an issue going to admissibility. And because it's an issue going to admissibility, the courts are not prepared to intervene. They are prepared to, in fact, defer to the tribunal. And so the challenge to the award was dismissed. So leaving aside the choice of an arbitral institution, I would suggest that in light of recent developments, it's important to first identify a law that governs the arbitration agreement, but also then think about what that law should be.
Well, that's very interesting. I'd like to come back to that and the implications of that, because I do think that's very important. Adeline, I had mentioned at the outset that one of the challenges in preparing these contracts is that with all these different strategic considerations, with all the other pressures that are generally on contracts managers and on people preparing and updating their contracts, a lot of time and manpower and energy is spent considering and thinking about these issues. And what I was wondering is, in your experience, is there any legal technology that can assist contracts managers in preparing and updating their contracts?
There are plenty. Hope I'm audible. But before I answer that, I just wanted to read the room to see how many of you are actually legal practitioners. For those of you who are legal practitioners, could you raise your hand, please? Right. So I would assume the rest of you are not from a legal background. Okay, great. So for the benefit of the crowd, in-house counsel has been using contract management systems for the longest time. And this contract management system can be anything as comprehensive as those that manage your entire contract lifecycle. Something like a Singaporean startup called Lexical has done. I'm also the co-chair for an NGO based in Singapore called ALITA, the Asia Legal Innovation and Technology Association. And Lexical won the most innovative newcomer entrant award last year. So what their platform does is they manage the entire contract lifecycle from time when you bring a new contract in, you start a file, you create an entire form where you are able to fill in templated contracts, and you would kind of mitigate the risk of not having certain clauses included, of not having typos within your contracts if you do it one by one. And from there on, you just kind of produce your entire contract, make sure everything is digitally signed, because digital signature is in the contract management platform. Get it signed. You can negotiate your entire contract on there because there's a collaborative platform included in it as well. So you can see, okay, this person has read my contract. Do you have any comments? Would you like to review any clauses? The person can put a tag in there and say, hey, I want to review this clause. This is not fair to me. And from there, you move on. You've agreed on all the clauses. You make sure, especially as a lawyer, that both parties understand what they're getting themselves into. And then you move on to the signature. And in time, you can get back to that contract through the platform to see your data and your analytics. So understand who has viewed those contracts, understand who has downloaded the contract and when. Because if that contract is downloaded a little bit later or much later after the contract has been concluded, it raises up a flag to those who are managing the contract, thinking, is there an issue with the contract? Would you like to review the contract? What is happening? Who is downloading it? So all these little things matter. So Lexical is one of it. Therefore, of course, your more expensive platforms, your LexisNexis of the world, your Thomson Reuters, of course they're good because they come with clause banks. They come with contract banks. So download your templates, download your clauses. Those with AI infused can even help you flag up red flags in your contract. So if your construction contract has issues in terms of your seat, in terms of the jurisdiction to hear it, then yes, those are things that can be flagged up if you have already put in a prompt. So I want to know about your jurisdictional clause. I want to know about the delivery clause. Those are things that can be flagged up in every single contract that you have done through the platform. And so it makes your life easier.
Yeah, I mean, I think that getting that kind of clarity in your agreement from the outset, for the reasons that you say, Adeline, and you, Pradeep, is very important. For the Malaysians in the room, I think, when it comes to multi-tiered arbitration agreements, one particularly important thing is to ensure that every stage of the dispute resolution tier is carefully drafted and complied with. And one particular case study recently involved an arbitration started by a Japanese company. The case, for those of you who are interested and want to note it down, is Yong Ah Huat and Toshiba. Toshiba started an arbitration against Yong Ah Huat and another company, and Yong Ah Huat went to the High Court and argued that the arbitration had been improperly started because there was a multi-tiered arbitration agreement, meaning that in this case, the parties to the agreement before going to arbitration were required to negotiate in good faith to try to resolve the issue. And the position that Toshiba took was, look, we've been negotiating for weeks, if not months now. Everybody is aware of what the dispute is. Everybody knows that, we don't agree. And so there's no point in continuing negotiations any further. Let's go straight for arbitration. The position that the plaintiffs took in court was the arbitration agreement requires a notice to be issued. And the notice was supposed to say, we are now supposed to start our negotiations. And then only does it count. Then only do you start your pre-arbitration negotiations. And what the Malaysian court ended up holding, relying on the Scottish Court of Inner Sessions, case called Ho, and a decision by Lord Drummond Young, that the test is practical commercial considerations. In other words, if everybody knows that there's a dispute and you've already been negotiating, then there's no prejudice to the respondent to the arbitration. But the other important lesson that it teaches is you don't have to get yourself into that kind of problem if you, from the beginning, very carefully follow the multi-tiered arbitration agreement. Unless either the panelists have anything else to add on the first topic, I was going to move to the second topic, which is the use of technology in preparing for and conducting arbitrations. And perhaps I'll just start with you, Pradeep, and perhaps you could share from your perspective of doing multiple Singapore arbitrations, especially with the SIAC, what sorts of tools you rely on in terms of managing large sets of documents and calling up those documents, and maybe any other technological tools you use in preparing for and conducting your arbitrations.
I think two come to mind: Zoom and Epic, I think, is the other service provider. I think one of the great benefits of arbitration is its flexibility. You have control over the process. You get to choose your arbitrators. You have control over the way the arbitrations run. And arbitration before the courts and well before the pandemic were forward thinking in the sense that because of the cross-border element, hearings conducted electronically were, I think, I wouldn't say the norm, but certainly not uncommon in arbitration. So, and that is something that seems to have accelerated post-pandemic. And so I think conducting an arbitration, a good platform that's steady on which you can conduct a hearing, documents can be called up, and you're able to toggle between screens for people in various jurisdictions, catering also for the requirement for interpreters is something that I think comes to mind. But the second thing is, especially in construction arbitrations, it's useful, I feel, to have from the outset a strong document management system. And Adeline, I'm sure, would be able to speak a lot more authoritatively on the subject. But I found, for example, having a good document management system from the outset where documents can be scanned, the text can be recognized, it's able to automatically tag documents. That's useful, especially in disputes of this nature where there tend to be industrial amounts of documents. The ability to impose control on the documentation, the ability to sort them, the ability to call out documents that bear certain keywords, certain tags, or that fall within certain timeframes, I found to be extremely useful in just being able to make sense of what's happened. And of course, that feeds into the ability to then present the case.
Adeline, maybe you could give us an idea of what the technological landscape looks like in the area of preparing for arbitrations, maybe in particular construction arbitrations, and conducting those hearings, because I think lawyers, we tend to use the systems that we're familiar with. So I've used Epic, Pradeep has used Epic before as well. There may be others, but we're not always aware of what is available out there and what that all looks like, what opportunities there are out there for use of technology. Perhaps you could give us an idea.
So Epic is one of the main players that both of you has experience using. In terms of players in the market, there are not many, honestly. So out there, apart from Epic, systems that can help you bundle documents, that's important. So where you're able to tag, where you're able to pull documents out from emails and file it properly so that everything makes sense to you.
Like virtual bundles.
Yes, like virtual bundles. So virtual bundling, my firm has helped to provide or prepare bundles for a number of disputes and arbitration internationally. And we have used eBrief Ready. And they are more cost efficient compared to some other larger players out there. And they can do the exact same thing. So it's not half as complicated as some of the larger players where you have to upload a whole bunch of documents, where you have to curate how the flow goes. eBrief Ready does that for you. It does the thinking for you. So we have been using it and we have been loving it when we are helping our clients with the bundling, when we are helping our clients with the preparation of the bundle itself. So, but for hearing, there is another company that's relatively new, although the founders are very, very known to the legal tech community, that is Litigation Edge. And I think the both of you should check that out because party would know the company for sure. Yeah. So in litigation age, you either have the human help you build your bundle and to help prepare for the hearing, or you can try to use their solutions. They are good for hearings. They are good to help prepare you for hearings, and they're more cost efficient than the bigger boys like Opus 2.
Yeah, I mean, I think both you and Pradeep have touched on really important uses of technology when it comes to preparing and organizing documents. I mean, a lot of you are involved in the construction industry or in construction disputes. As Pradeep said, you will all be aware of the enormous volume of documents that you can have. And I think sometimes, given the costs involved in dispute resolution, there can be some hesitancy in parties agreeing to not only spend an enormous amount of money on the arbitrator's fees and on their lawyers' fees, but then on these third-party external service providers. I mean, as Adeline has said, not all of them have to be that expensive, but certainly in my experience, and I think in both of your experience, it can be a lifesaver when you're in the middle of a hearing and you want to pull up a document. Either you yourself have the tagging, or very often the third-party service provider will have a document manager in the room. And you can just tell them, please pull up document with tag whatever number. And it can just come up on the arbitrator screen, the witness's screen, and everybody's immediately on the same page. I mean, I guess there are other creative ways in which to use technology. I mean, I was involved in an arbitration hearing where, in the middle of cross-examining a witness on, it was actually a QS, on her measurements, we were able to pull up the drawing in question and do a live demonstration for the arbitrator and for the witness to actually measure whatever she was supposed to be measuring and show that it was inaccurate. I wonder if that's something that you've come across before, sort of live demonstration software or other tech.
Honestly, live demonstration software, if you're able to just share a screen and you have a platform, even Paint, you can change your cursor around and say, hey, this is wrong, this is wrong. Of course, there are many ways to go around it, but I don't think I've come across any platform that is specifically for hearings and trials and arbitration for live demonstration. I've not.
The other question I had for you in particular, Adeline, is what are some of the strategic challenges in using technology that you've come across that legal professionals face?
I'm speaking from the position of an ecosystem builder for legal tech and legal innovation. I think the best people to answer what challenges legal practitioners face would be legal practitioners like yourself and Pardeep, right? What challenges do you face? But I think the biggest one is change management, because as you've mentioned earlier, it is a profession that is slow to adopt change, and for a good reason, because stare decisis, right? We follow precedents, and that's how our profession has grown so far. And in terms of adoption of change, we seem to have followed the same trend. We have not shifted far from it. So I think it's just mentality, really. That's the biggest challenge. Different jurisdiction has different stages of tech adoption. In Singapore, slightly better. Reason is because the adoption of technology is very much supported by the Ministry of Law. Law firms have grants in order for you to adopt technology, and that is great. So if those kind of funding support is also available to other jurisdictions from their own Ministry of Law, it's a cascading system, that would be a great foundation for a better ecosystem for legal tech innovation.
Great. I mean, I think when we're talking about the challenges that lawyers and parties face when it comes to introducing technology into preparing for and conducting arbitrations, That leads quite neatly into the third area that I'd like to explore with both of you, which is what sorts of protocols, what sort of steps can parties take in dispute resolution, in arbitration, to avoid conflicts arising either just before or in the middle of hearings with respect to the use of technology?
I'll make 2 points. And the first is a response to what Adeline raised earlier. In defense of lawyers, I think we're not as resistant to change and technology. I mean, there are going to be some who are a bit more resistant to change than the others, but I think increasingly lawyers will be the first to put up their hands and say that the changes, the advances in technology, they are there. They drive tremendous efficiencies in terms of costs and time. And lawyers, if we can spend less time doing something, we would very much want to do that. And the use of technology, I think, certainly helps. Like, just for an example, now, AI, it's the buzzword, everyone talks about it. The legal industry hasn't been spared, but legal research, I think, is being increasingly automated by AI. And I've used some of these products out there, and I find them to be quite phenomenal. Like, we're getting answers which lawyers ordinarily would have spent a day or two in the space of minutes. And you're getting not just cases, but there's technology out there that puts together a research memo, something which your associate would do. And it's being done in a space of minutes. And to me, that's a game changer. And it's like, it saves so much time. It frees up lawyers to work on other things. I hope it will reduce the chances of lawyers leaving the profession, because I haven't met too many who are thrilled about research, but research is foundational to everything we do. So that's one example, I think. And the second would be document management systems. You mentioned earlier that it tends to be a costly exercise. These services are not cheap, but again, the alternative is to have someone go through the documents, sort them out, review them manually. I mean, if you think about the time that's going to take compared to having software that helps you make sense of that volume of documentation, on balance, you're going to save a lot more time and costs. And that's great for you. That's great for the clients. So in defense of lawyers, we're not as resistant, I think, as it might be said. But when it comes to arbitrations, I think, again, the use of technology, it's there, it's becoming commonplace, but there's certain issues we need to deal with. And these issues include, for example, security and confidentiality of the material that's being put together somewhere in the cloud. There are concerns where various borders and jurisdictions are concerned about privacy of data. And it helps, I feel, to raise the issue, discuss the use of a particular protocol with the tribunal and the other side as soon as possible, preferably at the first case conference, at least get the conversation going. Because the sooner these issues are ironed out and a protocol can be agreed upon, more likely than not, the greater the savings in terms of time and cost that you will then enjoy.
Right. I mean, Adeline, in your experience, what are the sorts of technologies that lawyers, people involved in the construction industry, and those looking to manage disputes and arbitrations in the space, what sort of technologies should we be expecting? What kind of pitfalls should we be aware of when considering the sorts of things that Pradeep has raised, things that ought to be raised between the parties and maybe with the tribunal in a timely fashion?
The most efficient thing to me, and I'm not a practicing lawyer, although I do have a legal background, for parties in arbitration or in disputes in general, the most efficient thing is to just avoid disputes. So to avoid disputes, get your contracts in order. In order to get your contracts in order, don't simply get it from the internet and download a template and just use it. So for instance, in arbitration, for construction arbitration, AIAC has standard form contracts, and it has been there online on the AIAC website since 2019. You can download them, fill up the form, and that smart form is gonna port all the details that you've put in for the parties, for the contract, for all your obligations into a standard form contract, which is quite watertight, you know, given that AIAC has pretty good counsel and pretty good people in their team, and have that, download it, print it, and use that instead. So I think avoidance of dispute is the most effective way. Sorry to, you know, spill your rice bowl. But the other thing that you asked about, the pitfalls, right? Yeah. I think what you want to look for is something that is suitable for three things within your organization. You want to look for something that is first fitting to your budget. Don't invest in something just because it's cheap or just because it priced itself higher than market and you think that it's very good. And people tend to do that because, hey, there's LV, Gucci and whatnot, they're back, right? So don't think that it is luxurious just because they price themselves above a certain market rate. Try it. Don't take the quick way out. Try the platform, ask for a demo, ask for a trial period as much as you can, and just use it first. Because most of the clients that we have worked with who have adopted tech, 70% or more of the platform that they have invested in and adopted and probably subscribed for the 1 to 5 year period is unused. And that is investment wasted. You don't get good ROI from it. Although usage of tech cannot really be quantified in money in many organizational financial statements. You can't see the latency, but we can. So just try it first. That's one of the biggest pitfalls.
Great. I mean, we're reaching that time when we're going to open the floor up for questions. Before we do that, I'll just quickly summarize what I think my takeaways were from what Adlin and Pradeep have spoken about today. I mean, the first thing in preparing contracts, to be aware of what tools there are out there in terms of standard forms that you can use, the document resource banks that you can use, and the sorts of technologies that Alan was talking about that you can use in preparing contracts, which will highlight red flags in your drafting and things to look out for. Also, the critical considerations that Pradeep was talking about, choice of law, not just of the agreement, but of your arbitration agreement. And here I will also put in a good word for the AIAC, that the AIAC standard form arbitration agreements are excellent. And one of the advantages that Malaysia has as a jurisdiction for construction disputes is that the courts have held in various decisions that the courts will give a lot of leeway to professional and specialist arbitrators. For example, arbitrators who have particular experience in the construction industry, or arbitrators who are qualified engineers or QSs. And then when it comes to the sorts of technology that you can use in arbitration, to be aware that, especially for construction, document management systems are critical. They don't have to be expensive, but it's something worth looking into and worth investing in to make your disputes more efficient and run more smoothly. And finally, as Pradeep was saying, when you're in disputes, to agree with the other side and to flag to the tribunal as early as possible any technology that you might need to use. Say, for example, if you know that there's going to be a witness who's in another jurisdiction, sorting out things like giving evidence across time zones. if you're going to use a document manager, how you're going to tag the documents, what the tribunal is going to have access to, what the parties will have access to, those sorts of considerations. And with that, I'd like to thank both Pradeep and Adlan for their incredibly valuable insights, and open it up to the audience if you have any questions.
See, Malaysian audience very shy.
Okay, well, maybe I can ask this because they're both lawyers and non-lawyers in the room. How many of you in your work in the construction industry have used third-party document managers, either for managing projects or, say, in disputes? Do you mind if I ask what sorts of document management you've used?
Yeah, but it wouldn't help you because it was a Korean software.
But what, so was it document management?
Yeah, it was document management.
I see.
Specifically to manage documents from the very beginning of the process, but it was a genuine Korean software, so it wouldn't help. And I don't even recall the name. I was practicing in Korea, sorry.
Oh, no, that's
where it's
fine.
come
But I'm more interested in sort of how it worked. Like, did it do automatic tagging, the sorts of things that Pradeep was mentioning?
Yes, all of this work. It was challenging because while I do speak Korean, the interface and everything was in Korean. And there were a lot of terms that, you know, I would obviously not know because those are not terms you use in everyday language. But once you could remember where to click, you didn't even have to understand what it said. And it was tremendously helpful. And I was back then a senior associate slash, well, in Malaysia, we would call it a non-equity partner, right? So I was, to some extent, I had to do it on my own because of the specific language of those documents, not the interface, but the language of the documents. It was complicated. To some extent, I had to supervise, but I found it extremely helpful.
Okay, that's really interesting. Is there anybody in the room who does contracts management, who reviews your construction agreements and implements them? Nobody here reviews dispute resolution provisions.
They're all small prints, and then at the end of the agreement, you tick agree.
Okay, let me ask a different question. How many of the non-lawyers in the room have been involved in a construction dispute? Well, you're all very lucky. You'll never been involved in construction disputes. One gentleman. Oh, I see. Other arbitration disputes. Were those very document heavy? Oh, sure. Perhaps we could get that gentleman a microphone.
I was the CEO of a listed company in Hong Kong for a while.
Yes.
And we had a lot of legal actions. And at that time, my friends told me arbitration is a more flexible and quicker way to do these things. This is about 10 years ago, so I don't know whether the procedure is the same. But in Hong Kong, in the arbitration panel, the lawyer is present, you know, and we come to some kind of conclusion. And the client, I mean, the other guy and the lawyer goes to another room and comes back and say, we don't agree, you know, and that's the end of the thing. So it looks to me, the lawyer has no incentive to say to the client, this is the best you can get, you save more money. You know? And I tried a lot of arbitrations, and I told the CFO we'll be saving money. And after 6 months, they called me and said, Bala, you're not saving money. No? You're just adding more layers to the legal dispute. That's one thing. I don't know whether it's the same in Malaysia and other places. So how do you reconcile this fundamental problem, you know, from the client's point of view? That's one thing. The other thing is, how enforceable, a lot of construction companies in China, I mean, Malaysia, including my condo, seem to be from China, you know. How enforceable are your arbitrations or judgments in China? Yes.
Yeah, those are both very interesting questions. Your first question, how much time and money do arbitrations really save for the client? On that one, I mean, but you have some very good insights into how efficient, I mean, you've done countless arbitrations. I mean, how efficient is the process? How do you advise a client on, the client wants to vindicate their rights in a formal process, but at the same time, you have to consider what is really valuable for the client in terms of how far they take it.
I think that's an excellent question. And when someone starts by saying that's an excellent question, what that means is the question's a lot better than the answer you're going to get. See, the issue about whether arbitrations, are they going to be quicker? Are they going to be cheaper than court proceedings? It was promised that arbitration held initially, but it's an idea that's been long debunked. It's quite well established and accepted now that arbitrations need not necessarily be quicker or cheaper. And if you have complex construction disputes, difficult given the very nature of the disputes to want to run things along quickly and to do it at low cost. It's just difficult. So what do you do then? Now, a couple of ideas to explore. The first is increasingly around the world, the leading arbitral institutions, they recognize this criticism about the arbitral process and they've responded. Many of them now have something that's known as the expedited procedure. So if your claim, for example, is less than $5-6 million, you can, under the rules of that arbitral institution, seek to have your arbitration conducted on an expedited basis. And the aim is to have an award within 6 months, an example. So that's one way to, in a sense, achieve what I think you were initially promised, having your dispute resolved by arbitration, but quickly and cheaper. The second, and again, it's a response to the needs of the commercial community that's using the arbitral process, is third-party funding. Third-party funding is increasingly available in various jurisdictions. And one of the rationales, one of the arguments for why third-party funding is permitted in a number of jurisdictions is access to justice. And that concern, I think, resonates especially in disputes in this sector. I know if you get into a construction dispute, they tend to be complex, factually, technically, and they tend to run for some time. If you are the project owner, the employer, you might have deep pockets to be able to sustain the fight, but that's also not necessarily the case. If you are the contractor that's been out of pocket and is seeking to recover some money, the prospect of a long drawn-out fight can be a strong disincentive to even try to go for arbitration. So third-party funding is something that I would encourage people to think about. And that feeds me back to the point I led with, in some jurisdictions that's permissible, some it isn't. Whether it is permissible or not depends on the seat of the arbitration. So when you come back to crafting your dispute resolution provision, we spoke about using the correct arbitral institutions. We spoke about the importance of identifying the proper law of the arbitration agreement. But you would also want to think a bit more about the seat and whether third-party funding may be available. You may not have an immediate need for it, but it's always useful, I think, to be able to have the option.
Yeah, that's a really interesting perspective. I mean, on third-party funding, probably not available in Malaysia for the moment, but I know the AIAC has recently held an event with Minister for Law Reform in Malaysia to discuss exactly this issue of third-party funding. So I guess watch the space. The second part of your question, enforceability of awards in China arbitrations in Malaysia. So, I mean, I think from the Malaysian perspective, two issues. The first is, yes, I mean, you can register an arbitration award with our courts and you can seek to enforce. But there's a more practical issue, which is when you want to enforce, where are the respondents' assets, right? If there are assets in Malaysia, yes, there are ways you can enforce here. But very often, all the assets will be in a foreign jurisdiction, either China or some other foreign jurisdiction. And that can be very challenging because you then have to approach lawyers in that jurisdiction. And then maybe both legal and practical reasons why it may not be possible to enforce the award. So from a technical legal standpoint, yeah, you can register your award in the court of Malaysia. But when you come to enforce, it depends. There is. And I think when it comes to efficiency of arbitration, it also feeds back into what you were talking about, because maybe the traditional way in which arbitrations are run, document heavy, human being heavy. Maybe this is another way in which we can achieve efficiencies.
I think first and foremost, also the practitioners and arbitrators, counsel in arbitration needs to be incentivized to think about the efficiency. Yeah, because there are many jurisdictions, like Malaysia as well, where hiring a person is cheaper than your subscription fee for a very good software, for instance. So you just throw bodies on it just because it's easy. Yeah.
Yeah, yes.
Thank you. I have a question to Pradeep on the law governing the arbitration agreement, or maybe it's a comment, more of a question. Let's see how I take it. Now, most of what you say, I fully agree with on the one hand. On the other hand, I'm gonna challenge what you said, if I may. A friendly challenge, though. Now, why is it, even though you and I both agree, and a lot of other people, that to the best of my knowledge, the only two major arbitral institutions out there who have the law governing the arbitration agreement as part of their model clause, namely the HKIAC, which I believe was the first one ever out there, and now the AIAC since 2021. Why is it that there's only two out there on the one hand, and on the other hand, and maybe that's the answer to it, how can we expect commercial parties and contract drafters to even remotely grasp the consequences of determining the law governing the arbitration agreement when, and I dare to say this now, a major chunk of arbitration practitioners have never dealt with an issue where the law governing the arbitration agreement really played a role. I'm speaking out of my own experience, which is 80 plus arbitrations. I had the issue 3 times. And when it arose the last time, I reached out to a couple of friends saying, is it just me, or is that the standard? And all my friends, pretty much all across Asia and in Europe, had the same experience. It really was an issue that almost never arose. Thank you.
Thank you. I don't consider that to be a challenge at all, actually. I think it feeds exactly to what I was saying, which is it's an issue to which not many people pay attention, yet it tends to have serious practical consequences. And I think, if I may put it this way, in friendly terms, you've answered your own question. Your standard form clauses don't provide for that. In other words, key proponents in this sector, they themselves haven't quite applied their minds to it, much less would you expect others or laypersons, the commercial persons, to do that. But it's an issue which, in recent cases, it's rearing its head, and it's a real issue, and it's an issue that is the subject of, in some jurisdictions at least, legislative intervention. In England, for example, they are now amending the Arbitration Act to provide as a default rule that if the parties do not identify the law of the arbitration agreement, then it's the law of the seat. That move in and of itself, I think, underscores the fact that this is something that is of tremendous practical importance, such that it has deserved legislative intervention. And England is one jurisdiction. I think Singapore's doing the same. And I also think, I could be wrong, but I also think other major arbitral institutions have started to revise their standard clauses to provide specifically for the law that governs the arbitration agreement. And it's something they've had to in view of the recent slew of cases dealing with these issues. And so I suppose the short point is that you're spot on when you say it's not something that's deserved enough attention, but I think it is on the agenda of the international arbitration community. Recent cases, I think, have demonstrated the importance of paying attention to it. And I do expect in the near future, at least, that in contract drafting, at least, these issues will be addressed and hopefully thereby reducing the sort of litigation that I described earlier.
Okay, we're just about at time, but if it's okay with Brian, I think we can take a few more questions.
Hello, I'm AJ Surin from SRL in KL.
Hi.
One of my areas of practice is actually TMT. I was actually fascinated with this statistic that you actually gave, Adeline, which states that 70% of technology which is procured or implemented in law firms are actually not used. So I'm interested to know, where that statistic is from, whether it's actually, some sort of a comprehensive study or research which has actually been done, because, lawyers are very hard to convince. They are logical, they are analytical, and, they always, look at all angles. So I'm curious to know about that. Thank you.
In Malaysia, there's no official study on this at all. There's no comprehensive study. So the statistics come from my own study because I'm fascinated by data analytics and I'm just a nerd. And so among the clients that I have consulted who wants to implement new workflows within their legal firms, I have sent out survey forms before I give the consultation to understand what their law firm use, how much do they use, and how familiar they are with the current software that they have before I give out a consultation and a proposed solution to them. And that is where I calculated the statistics from. So it is a data that I have collated from clients that have consulted me in terms of legal technology and tech stack to use. And it is something that I really, really wish to have studies conducted on. It is part of my thesis when I was doing my master's, and it is something that I want to look into further if I can pursue my PhD when I do have the time to pursue my PhD.
Thanks. Do we have any other questions? Okay, if there are no other questions, thank you very much again, everybody, for attending. Yeah. And thanks again to Brian and the AIAC for organizing this.
Thank you to our panel of speakers and moderators for the insightful session. May I kindly request the panel to stand at the front of the table. I would like to invite Mr. Brian Richard, the head of AIAC's business development, to present the token of appreciation. And with that, lady. Oh. And with that, ladies and gentlemen, we have come to the end of our evening talk. We look forward to meeting you all again in our next session. Please make your way to seminar room 2 for food and drinks and for the networking session. Thank you and have a great evening ahead.